Alright, 6050119, waiver of notice. If pursuant to the chapter, articles, organization, operating arrangement of limited liability company not is required to be given to a member of the limited liability company or to manage the limited liability company, having a manager or managers a waiver written signed by a person or person entitled to the notice, whether made before or after the time of notice to be given, is equivalent to giving the notice. 6050201, formation of limited liability company, articles of organization. One person may, as an authorized representative to limit for a limited liability company, as a signing or delivering articles of organization of the Department of the filing. The articles of organization must be state the following: the name of the limited liability company, which complies with the statute 6050112, street, mailing address of the company principal office, the name of the street and address in the state, the written acceptance of the company's initial registered agents. The article organization may contain in matters other than required under subsection 2 may not verify otherwise other affect the provisions in statute 605-105 in the manner inconsistent with subsection. Additional statements may be included one or more of the following: a declaration to whether the limited liability company is managed for a purpose of statute 605-0407 other relevant provisions of the chapter for the managed limited liability company, the names and address of one or more of the managers of the company. A manager managed limited liability company, name and the address of one or more of the members of the company, a description, authority, limitation, authority of the specific person in the company with the person holding the position having a specified status with the company, any other relevant matters. Limited liability company is and for when the company articles organization become effective under statute 6050201 when at least one person becomes a member of the title articles organization because effective being signed of the articles organization. Person who signs the articles affirms the company that his will have at least one of the time of the articles organization must be effective. 605-0202, amendment of the reinstatement articles of organization. Articles of organization may be amended and reinstated at time to amend the articles of organization. Limited liability company must deliver to the Department of the an amendment designated as to such as into its heading, which contains the following: the present name of the company, date of the filing, company articles of organization. The amendment of the articles of organization delayed, defective date provided with the state statute 605-027. If amendment is not effective within the date of the department is amended to the articles of the organization. Limited liability company must deliver to the Department of the instrument entitled the reinstatement of the articles of organization, which contains the following: the present name of the company, the date of the filing of the articles of the organization, all the provisioned articles of organization effective reinstated. The daily effective date is provided under 605-0207. The reinstatement is not effective on the date of the Department of the files the reinstatement. The reinstatement of the articles of organization of a limited liability company may also contain one or more amendments to the articles of organization, which such case the instrument must be entitled to the amended reinstated articles of organization. If the member managed limited liability company and manager of the management limited liability company knew the information contained with the finding of the articles of organization incorporating the articles of organization will file, but because in the articles also due to the circumstances members shall promptly cause the articles of organization to be amended if the appropriate delivery of the Department of the filing statement and changed under the statute 605-0114 or the reinstatement the correction of 605-209. 605-203, signing in the records to be delivered with the filing to the department. A required delivery to the department of the filing pursuant to the chapter must be designed as follows, except otherwise paragraph B and C. As recorded, the sign on the behalf of the limited liability company must be signed as the person authorized by the company. Accompanying articles must be signed at least one person as an acting and authorized representative. Articles of authorization must include and have an attached statement signed with the company's initial registered agent in the form of described in 605-01132. A recorded delivery on the behalf of the dissolved company that has no member must be signed by a person winding up with the company activities of the affairs under 605-0709 3, or a person appointed by the 605-0709 4 and 5 to wind up with the activities of affairs. A statement of the denial of the person under 605-30303 must assign the person in the record chain to the registered agent must include them being accompanied by the statement signed in the successor registered agent in the form of the described 605-01132. If in the record delivered on the behalf of the person, the department must be signed as that the person. A record may also be signed by an agent, legal representative, attorney, in fact, as applicable if such a person is duly appointed as authorized to sign a record of the record statements of the person who possesses the authority. A person who signs the record of the agent, legal representative, attorney, in fact, affirms that the fact if the person is authorized to sign the record. 605-204, signing and filling pursuant to the judicial order. If the person required under this chapter to sign a record and deliver with the record of the department under the chapter does not do so, another person is aggravated by the aggrieved by the petition. The circuit court to order the person to sign the record of the person to deliver the record of the department of the filing file record unsigned. If the petition under subsection 1 is not limited to the company foreign limited liability company to which the record pertains, the petitioner shall make the limited liability company foreign limited liability company a party to the action. A petitioner may speak of the remedies provided with subsection 1 in the same action combination or in the alternative. A record filed by the pursuant of paragraph 1 and 2C is effective without being signed. 605-205-206. 605-0205. Limited liability inaccurate information in file record. If the record delivered to the Department of the filing under the chapter filed by the Department contains the inaccurate information, a person who suffers the loss reliance on such information may require the damages for the loss. A person who signs the record caused with another to sign the person on the behalf knowing the information is inaccurate at the time the record was signed. Subject to subsection, a member of the managed limited liability company and a manager limited liability company. The record was delivered on the filing behalf of the company. The member of the manager had noticed the inaccuracy for the reasonable sufficient time before the information was relied on before the release of the management responsible could have. Effected as an amendment pursuant to section 605-0202. File the petition pursuant 605-0204. Deliver the Department of the filing statement of the change pursuant to 605-0114 and or statement of the correction 605-02209. To the extent of the operational agreement, the member managed limited liability company expresses lives on the member of the responsibility for maintaining the accuracy information contained in the record delivered on the behalf of the company and the Department of the filing imposed the responsibility on one of the more members. The liability stated in paragraph 1 and 6 applies to the members, not to the member of the operating arrangement, relieves the responsibility. 3. The individual who signs a record is authorized to be required to fill under the chapters affirms under the penalty and perjury the information stated in the record is accurate. 605-0206 filing requirements. A record authorized required to be delivered to the Department of the filing under this chapter must be captioned to describe the record purpose of being a medium authorized the Department to deliver to the Department. It is filing fees are paid. The Department shall file the records unless the Department determines the record does not comply with the filling of the requirements. Upon request payment of the applicable fee, the Department shall send the requester a certified copy of the request or record. If the Department prescribed with a mandatory medium on the form to be required being filled, the record must be prescribed medium or by the prescribed form. Except otherwise provided with the Department, a document made to be filed. The Department must be typewritten, printed, legible, written in the English language. It may be limited liability company does not need to be in English if written in English letters or Arabic or Roman numerals, and certificate existence required for foreign limited liability company does not need to be in English and have accompanied a reasonable authenticated English translation. The Department may prescribe the electronic format which comply with this chapter. The Department may also use the electrical transmission for the purpose of the notice of communication in the performance of the duties require files registrations to furnish email addresses when present in the document and filing. 605-0207 effective date. Expect otherwise provided by the in statute 605-0208. The subject 605-0209 amended with the delivery of the Department of the filing under this chapter must specify effective and delayed of the effective date. In the case of the in articles of the organization, prior effective date must be specified in articles of organization in such a date as in 5 business days after the date of the filing. Subject 605-0114, 605-115, 605 0208, 605-0209, record filing the Department effective. 1. If the record does not specify the effective time, does not specify prior to the delayed effective date of the date and the time the record is filled with the evidence Department endorsement of the date of the time the record. 2. If the record specifies an effective but not a prior to the delay effective date on the date of the record is filed at the time time specified in the record. If the record specifies or delayed effective but not effective time until at the 12:01 a.m. on earlier than the specified date, 90 days after the record is filed. If the record in the articles of organization specifies the date before effective date but not effective time at 12:01 a or later, the specific day and the fifth business day before the record is filed. If the record's initial articles of organization specify an effective time and delayed effect specified time earlier specified date, the date and 90 days after the record is filed, the record specifies an effective time of the primary effective date is specified or later, the specified date or 5 business days before the record is filed. 605-208, withdrawal of filed record before effectiveness. Expect otherwise provided by the statute 605-1001, 605-1072. Record delivered in the department filing with the withdrawal is taken by, in effect, delivering the department of the filing within the withdrawal statement. Withdrawal statement must be signed at each person with the signed record be withdrawn, except for the otherwise agreed upon by those persons. Identified by the record to be withdrawn, if not signed by the person signed by the record withdrawn, stated the record was withdrawn in accordance with the agreement at all persons who have been signed and record on the filing department of the withdrawal statement. The action, transaction, evidence of original record does not take effect. 605-209, correcting filed record. A person on whose behalf of the filed record was delivered to the department in filing may be correct the record. Record at the time of the filing was inaccurate. The record was defectively signed. The electrical transmission of the record to the department of the effective correct the filing record. The person whose behalf the record was delivered to the department must be delivered by the department in filing a statement of the correction. A statement of the correction may not say a delayed effective date. Must be signed by the person correcting the filed record. Must identify the filed record to be correct. It must specify the inaccuracy, defect, and to be corrected. Most correct inaccuracy or defect, the statement of the correction and the effective date of the filed record that the corrects, except for the purpose of statute 605-0103, the person is relying on uncorrected field with the adversely effective for the correction for the purpose of those the person's statement of the correction is effective when filed. 605-02-110, duty of the department to file the review of the refusal to the filed transmission information by the department. The department files the document stamping, otherwise endorsing the document filed together with the department official title and the date and the time of the receipt. After the filing, the record, the department shall deliver the acknowledging the filing, the certified of the document to company of the foreign limited liability companies as authorized representative. 3. The department refuses to file the record, the department shall, within 15 days after the record is delivered, return the record, notify the person who submitted the record of the refusal. 4. B. Provided the brief explanation of the record of the reason for the refusal. 4. The application returns the document with the corrections in accordance with the rules department within 60 days after it is mailed. The application of the department, and if the time that would have been applied for the original documentation not be deficient, except for the as the person who has relied on the before the correction adversely affected thereby. The department's duty to file the documents under the section of ministerial filing. Refusing the document does not affect the validity, invalidity of the document as in a whole part of the relate the correction, incorrection information contained in the document, created the presumption of the documentation valid information contained in the document and is correct and incorrect. And otherwise provided the law in the chapter of the document, department shall determine the rule, the appropriate format, the documentation under the jurisdiction, number of the copies, manner of the execution, method of electrical transmission, amount of the method of fees, such as the documents. If the department refuses to file the record, the person submitted with the record petition in the court to compel the filing of the record. The record explanation of the department of the refusal must be attached to the petition. The court may decide matter in summary proceeding. Except otherwise provided by the statute 605-0117 and by any law other than the chapter, the department must deliver a record of the person delivering it to any person who is submitted to address the person registered in the principal office of the person to any another address of the person provides the department for delivery. Which one is it? Certificate of status. The department, upon the request permit, that the requisite fee shall be issued the certificate of status of the limited liability company if the records of the file of the department show that the department has associated with the file company the articles of organization. The certificate of the status must be stated as the following: the company's name, the company was organized under the law of the state, and the date of the organization, whether all fees due to the department under this chapter have been paid. If the company must a recent annual report under the statute 605-02-112 12 have not been filed with the department. If the department has administratively dissolved the company, the received the record notified of the department of the company has dissolved by judicial pursuant as section 605-07025. The department of filing the articles of dissolution of the company. The department has been accepted and filed the statement of determination. The department, upon request payment of the request fee, shall furnish the certificate statutes of the foreign limited liability company if the record filed showed for the department had filed the certificate of authority. The certificate of status of a foreign limited liability company may be the status of filing. A foreign limited liability company, the current alternative new adopts under Statute 605-0906 for this use. But the foreign limited liability company is authorized to transact the business to state whether all fees, penalties due to the department under this chapter other than the law have been paid. If the foreign limited liability company must recent annual report required of the statute 605-02112 has not been filed with the department. If the department has 1. Revoked the foreign limited liability company's certificate of authority, 2. Filed a notice of withdrawal of the certificate of authority, and 3. The subject to qualified state of the certificate status, the certificate of status issued by the department of the conclusive evidence of limited liability company in existence of foreign limited liability companies authorized to transact a business in state. 6012. Annual report of for the Department of Limited Liability Company. The registered foreign limited liability company shall deliver the Department of the following annual report for the state of the following: the name of the limited liability company, the foreign limited liability company, the name under the foreign limited liability company registered to transact the business estate, street address of the principal office and mailing address, the date of organization, foreign limited liability company, the jurisdiction and formation date of the became qualified to transact the business and state, the company of the company of the federal employer identification number, and if no one other has been applied, the name, the title, capacity, the address, at least one of the person who authorized the manager of the company, any additional that is necessary appropriately enable the department to carry out this chapter. Information annual report must be certain of the current of the date that delivered on the department of the filing. The first annual report must be delivered to the department between the January 1st and May 1st of the following year, the calendar year in which the limited liability company articles organization must be effective on the foreign limited liability company's object of certificate of authority, and to the transact business in the state. Subsequently, annual report must be delivered to the department between January 1st and May 1st of each year, calendar year thereafter. If one or more of the forms the annual report are submitted to the calendar, the department shall file each of them, make an information contained with the part of the official record. The first to inform the annual report of the calendar year shall be considered with the annual report calendar year. Each report filed after the same calendar shall be treated and amended with the report of the calendar year. 4. If an annual report does not contain information required in this section, the department shall promptly report the limited liability company, registered foreign limited liability company, if the report is contained with the information required in subsection 1 and delivered to the department within 30 days after the effective date of the notice is timely delivered. If an annual report contains the name and the address registered agent that differs from the information shown in the record of the department immediately before the annual report becomes effective, the differing information annual report is considered the statement of change in statute 605-0114. Limited liability company, foreign limited liability company that fails to annual report with the comply with the requirements of the section may not maintain or defend any action of the court of the state until the report is filled out with all fees, penalties due under the chapter and are paid shall be subject to the dissolution, cancellation certificate, authority to transact businesses provided by the chapter. 7. The department prescribes which may be electronic form in which to make annual report called in this section may be substitute uniform business report pursuant to section 60606 means to satisfy the requirements of this chapter. As a condition merger of the 605-1021, each party is merged to exist under the law of state. Each party to the merger which exists under the law under the jurisdiction has the authority, certificate, authority to transact business or conduct in this affair of the states. Must be active in current in filing initial annual reports are recorded. The department of the December 31st of the calendar year, and the articles of merger submitted in the department of the following. 9. Is a condition conserving the entity of the limited liability company under 605-1041. The entity exists under the law of the state, and they exist under the law other than jurisdiction of the certificate of authority transact business or conduct in its affair with the state must be achieved the current filing in its annual reports of the reports of the record of the department through the department 31st calendar year in which the articles are conserved submitted to the department of the filing. As a condition of conversion, limited liability company to any other than any of the statute 605-104, limited liability company converting onto the type of the entity must be activated by the current filing in initial annual reports of the department through the December 31st of the calendar year, and the articles concerns conversion as submitted in the department of the filing. As a condition of interest, the exchange between a limited liability company and any other entity under 605-103-1, limited liability company and each other entity their party to the interest exchange exists of the laws stated under each part of the interest exchange, which exists when the laws under the jurisdiction have the certificate of authority to transact the business connected the fair to in the state must be active for the current filing and annual reports of the record of the department of December 31st of the calendar year and articles of interest exchange is submitted to the department of the filing. 605-0213, the fees of the department. The fees of the department under this chapter are as follows. The furnished certified copy for $30. A full furnished certified copy is $30. Filing original organization articles of revocation is or dissolution is $100. For filing limited liability company application of certificate of authority as transaction business is $100. The filing certificate of merger liability companies and other business entities $25 per consistent per merger unless the specific fees are required of the party under the applicable law. For filing an annual report, $50. For application reinstatement, administrative judicial dissolution, revocation of authority, transaction, business, $100. For certification, designation, registered agent, changing a registered agent, $25. For filing a registered agent statement of resignation, active limited liability company, $85. For filing registered agent statement of the redesignation from the dissolved limited liability company, $25. For filing certificate of conversion of limited liability, $25. For filing a limited liability company of $25. For filing a limited 11. For filing any other limited liability company document, $25. For furnishing the certificate of status, $25. 605-0214, power to the department. The department has the authority to responsible necessary to administrate the chapter efficiently to perform the duties imposed upon it and adopt the reasonable rules necessary to carry out the duties and functions under this chapter. 605-0215, the certificate has received the evidence of evidentiary effect of the company of the filed document, and all certifications issued to the department in accordance with the chapter shall be taken and received in all courts, public offices, of official bodies, and the prima facie evidence of the stated. The certificate of the department delivered the copy of the document filled with the department inclusive evidence of the original document in which the department. 605-2016, statement of dissolution or resignation. A member of the limited liability company may file the statement of dissolution with the department containing the following: the name of the limited liability company, name, the signature of the dissociation member, the name of the date of the member withdrew and withdrew. The statement of the company has notified the dissolution of the the statement of the company that has notified the dissociation in writing. The manager or the manager managed limited liability company may file the statement of resignation of the statement resignation of the department of containing the following: the name of the limited liability company, name of the signature of resigner manager, the date of the resigning of the manager, resign and will resign, and the statement of the limited liability company that has not been notified resignation of in writing. 605-0301, power to bind limited liability company. A person does not have the power to bind limited liability except for the extent of the person is agent of the company to virtue. 605-04074, the authority to do so. Articles, organization, operating arrangement of the company has the authority, but due to the statements authorized filed with the 605-0302 has the status of agent, have the company authority to power and to bind the company under the law under this chapter. 605-0302, statement of authority. A limited liability company may file a statement of authority. This statement must include the name of the company and it appears in the record of the department in the street and the mailing address of the principal office with respect to the specified status of the position of the person in the company, whether a member of the transferee, manager, officer, or otherwise, may state authority, limitations of the authority of the person having status holding the position. 1. Execute the instrument of transferring real property held in the name of the company, entering the transaction on the behalf of the otherwise act of the binding of the company. C. May state the authority to limitation of the authority of a specific person. 1. Execute the interest transferring real property held in the name of the company. 2. Enter the alert transaction on the behalf of the otherwise otherwise act for the binding of the company. To amend for the cancel statement of the authority filled with the Department of Limited Liability Company must deliver the Department of the amendment of the cancellation statement of the following: the name of the company as it appears on the record of the Department, the street mailing address of the limited liability company of the performance principal office. The date of the statement being effective, becoming effective. Contents amended. The declaration that the effective statement is canceled. The statement of authority affects not only the person of the bond limited liability company. 2. The person who is not a membership of the subject section 3 and 605.103 4, except for the otherwise provided in subsection 6 and 8, limitation of authority of the person's status and the position contained in the effective statement of authority and its evidence, knowledge, and notice and limitation subject section 3, 605.0407, 605.4074, grant authority not pertaining to the transfer of real property contained in the effective statement of authority and conclusive with the favor of a person gives value to the reliance on the grant except for the extent that the person gives the value. The person with knowledge and contrary the statement that has not been canceled or restrictively amended with under subsection 2. C. The limitation of the grant is contained within another statement of authority that becomes effective with the statement containing the grant became effective. Subject to subsection effective statement of authority of the grants authority to the transfer of real property held in the name of the limited liability company, certified copy in which the statement is required to the office recording the transfer of the real property in conclusive with the favor of the person who gives the reliance of the grant without knowledge on the contrary except for the extent with the person who gives the value. The statement has been canceled restrictive amended under subsection 2 with a certified copy of the cancellation. Restrictive amendments have a record of the office and the recording transfer of the real property. B. Limitation of the grant containing the information of the statement of authority has become effective with the statement containing the grant of becoming effective and the certified copy later an effective statement is recorded in the office regarding the transfer of the real property. Subjects to subsection 3 is certified copy of the effective statement of authority containing the limitation of authority to transfer real property held in the name of the limited liability company as required in the office of recording transferring real property. All personnel are deemed to know the limitation subsection effective in the dissolution, termination, effectual cancellation field statement of authority. The purpose of the section limited authority of the subsection 9. After a company's article of dissolution becomes effective, the limited liability company may deliver the Department of the filing, if the appropriate, may require the statement of authority in accordance with subsection 1 of the designated pre- and post-dissolution statement of authority. Statement of appropriates is provided in subsection 6 and 7. Unless earlier canceled, an effective statement of authority is canceled in the operational law of 5 years on the date of the statement, and most amendments must become effective. The cancellation operation without need for a recording under subsection 6 and 7 of the effective date denial operates. A restrictive amendment under this section may be recorded and certified for the purpose of 6A. 11. Statement of dissociation with the statement of reorganization filled with the statute 605.0216 terminates the authority of the person who has filed the statement. 605.0303 statement of denial. The person whose name in the final statement of authority granting the person authority may deliver the Department of the filing statement of denial signed by that person provides the name of the limited liability caption of the statement of authority. The statement of denial pertains and denies the grant authority. 605.0304 limited liability managers. Liability of members and managers. A debt obligation of other limited liability company is solely debited the obligation of other liability company member, the manager, not personally liability directly and indirectly with a contribution otherwise for debt and the obligation of other liability company, and he's sole and responsible being as acting as a member of the manager. The subsection applies regardless of dissolution of the company. The failure of limited liability company to deserve relates to the exercise of the powers, management of the activities, affairs, and not on ground imposable liability of the manager company and the obligation of other limited liability company. The limitation of the liability in section in addition with the limitation of liability provided in statute 605.04.093. 605.04013. If a limited liability company has only one member, then upon its information, the person may become the member as an agreed that by the person that authorized representative of the company. The person may authorize, and the authorized representative may be not needed the different person if the different person's authorized representative acts on the behalf of the initial member. 2. The limited liability company is to have more than one member. Upon for information, those persons become the members of the. As agreed, the person becomes the formation of the company. The authorized representative acts on the behalf of the person informing the company may not be one of the persons after the formation of a limited liability company, a person becomes a member as provided with the operating arrangement as a result of merger, interest, exchange, conversion, or domestication under statute 607, 605, 1001, 605, 1072 is applicable with the consent of all members as provided in 6057013. A person may become a member without acquiring the transferable interest without being obligated to make the contribution limited liability company. 6050402 form of contribution. The contribution may consist of tangible, intangible property, other benefits of the limited liability company, including money of the service performed, the promissory notes, other arrangements, and contributed money and property contracts for services to be performed. 605-403, limited liability of contribution. A promise by a person to contribute to the limited liability company is not enforceable unless it is sent out in writing signed by the person. A person's obligation to be contribution for the limited liability is not excused from the person's disability or the other ineligible ability to perform the personally. If the person does not fulfill the obligation to become a contribution other than the money, the person obligated by the option limited liability company to contribute the money equal to the value of the part of the contribution has not been made. The foregoing option is additional, not to be in lieu of other rights, including the right of the specific performance limited liability company may have against the person under the Articles of Organization, Operation, Agreement, and applicable law. For the obligation of the person to become the contribution may be compromised only by the consent of all the members. If the creditor and limited liability company extends the credit and otherwise acts in reliance on the obligation described in subsection 1, without notice of compromise of the other subsection, the creditor may enforce obligations. 5. An operating arrangement may provide a limited liability company interest member who fails the contribution. The member is obligated to make the subject of specified penalties, specified consequences for the failure. Penalty of the consequences making the form of the reducing and elimination of defaulting member, the proportionate interest in the limited liability company subordinate defaulting member's limited liability company interest of that non-defaulting member as a forced sale of limited liability company interest forfeiture of the defaulting member's limited liability company interest, lending the other members the amount of the necessary meeting of the defaulting member to commitment, fixing the value of the defaulting member limited liability interest and appraisal of the formula, redemption and sale of the defaulting member's limited liability company interest as such value or other penalty or consequence. 605-0404, sharing, distribution, and dissolution of profits and loss. Distribution may be limited to liability, but before the dissolution, winding up the vote must be shared by the members of the person dissociated with the members on the basis agreed as stated with the company. Records of the contribution may be made with the person dissociated with the member, extent of the contribution received with the company, extent necessary to comply with the transfer effective under section 605-0502, charging in order to 605-0503. A person has the right to distribution, performance, dissolution, winding up limited liability company only after the company decides to make an intern distribution. In-person dissociation does not entitle the person to distribution. A person does not have the right to demand and receive distribution from the limited liability company in the form of other money, except for the otherwise provided in the 605-0710 for the limited liability can distribute in assets of the kind, and if each other part of the assets is fungible with each of the other parts of each person receiving the percentage of the assets of the quality and the value. The assets are equal to the value of the person's share of the distribution. If the member of the transfer has become entitled to receive the distribution, the member of the transferee has the status of and entitled to all remedies available for the creditor, limited liability with respect to distribution. Profits and losses limited liability company may be allocated among the members, personal dissociated members of the basis agreed value stated in the company record. The distribution company may be made, and each member of the person limited associated with the members to extent that the contributions have been received by the company. Limited distribution, 605-0405, 605-0405, limited distribution. The limited liability company cannot make distributions, including distributions under 605-0710. After distribution, the company would not be able to pay the debts if it has become due to the ordinary course of the company's activities and affairs. The company total assets would not be less than the sum of its total liabilities, plus the amount would be needed. The company wants to be dissolved and would be upon the time of the distribution safe to satisfy the preference preferential rights of dissolution winding up to the member's transferee, whose preferential right of the superior to those persons receiving the distribution. 2. The limited liability company may determine the distribution is not prohibited under subsection 1 of the financial statement prepared with the basis accounting the principles of the reasonable under the circumstances. B. The fair evaluation of the method of reasonable under the circumstances except otherwise provided in subsection 5. The effective distribution under subsection 1 is measured. A. In case of the distribution, the purchase, redemption, and other acquisitions of a transferable interest in the company or as an earlier date of which 1. The money other than property transfer the debt is incurred with the company. 2. The money entitled to the distribution causes the interest of the right being acquired with the company to return the distribution. B. In the case of the distribution, indebtedness, the date of the indebtedness is distributed. C. In all other cases, the date of which the distribution authorized by the payment under the occurs with 120 days of the payment made, and the payment occurs in the 120 days after the distribution is authorized. 2. Limited liability company indebtedness member to the transfer in court of the reason the distribution made in accordance with the section priority with the company's indebtedness to the general unsecured creditors except for the extent of subordinates by agreement. 5. Limited liability companies indebtedness includes the distribution not a liability for the purpose of subsection 1 of the term indebtedness provides the payment of the principal interest and that is made only in the extent of the distribution could be made under the section of the indebtedness is issued distribution in terms provided the payments of the principal and interest of the made only for the extent of the distribution could be made under the section that each payment of the principal interest of the indebtedness is treated the distribution the effect of the measured on the date of the payment is actually made and measuring the effect of distribution under the 6050710 liabilities of dissolved and limited liability companies do not include claim the disposed under section 6050710 6050713 6050406 limited liability of improper distribution, except otherwise provided in subsection 2. The member managed limited liability company manager managed limited liability company consistent with the distribution made by the violation of statute 6050405 and consistent with the distribution fails to comply with 6050491. The member the manager personally liability for the company for the amount of the distribution which exceeds for the amount that could have been distributed without the violation of statute 6050405. To the extent of the operational agreement, the member managed a limited liability company expressly relieves the member of the authority responsible to consent to the distribution imposes the authority responsibility on one or more of the members of the liability. Subsection 1 applies for the other members and not member of the operating arrangement relieves the authority responsibility. A person receives distribution knowing that the distribution violated in 6050405 is personally liable then limited to company but only with the extent of the distribution received the person exceeding the amount that could have been properly paid on the 6050405. The person against whom the action is commenced becomes the basic because of the person that may be liable under the subsection section 1. Implied another person who is or may be liable under subsection 1 is to seek the enforcing the right of the Iowan's contribution for the person in play of person who has received distribution violation. Subsection 3 seeks to enforce the right of the contribution implied by the person the amount of the person receiving the violation of subsection 3 and action under the section barreled unless it commenced within 2 years after the distribution. 6050407 limited liability company member management limited liability company unless operating arrangement articles organization A expressly provide the company is will or be manager manage the company is or will be manager managers the company is or will be vested managers and include the similar import that the subparagraph A1 through and 3 unless the context of expression is used otherwise required the term the managing members do not and in and of themselves constitute work in their similar import of the purpose. If a manager manages the limited liability company, the management and conduct of the company are vested in the members except for the expressly provided with the chapter. 3. And the manager manages a limited liability matter relating to the activities affairs of the company decided the exclusive manager and other there is more than one manager of the manager except for the expressly provided in this chapter. Remember the entitled remuneration for the service performed for a member of the managed limited liability company except for the reasonable compensation for the service rendering and the winding of the activities and affairs of the company in the absence of the agreement to the contrary. For a limited liability company shall reimburse the member for the advance from the company beyond the amount of the capital of the member agreed to the contrary. The distributed limited liability does not affect the applicability of that section 6050407 6050474. However, the person wrongfully causes the dissolution of the company loses the right to participate in management as a member and a manager. 6050471 delegation of rights to management powers to manage. A member of the manager is limited to liability for the power of the authority to delegate one or more of the persons, members, or managers, as the case may be. The right of the powers to manage and control the business and affairs of limited liability company, including power, authority to delegate the agents, bonds, the managers, members, the directors, of officers, assistant officers, employees of a member of the management and limited liability company, the power authority to delegate the member of the agreement, a similar agreement with and otherwise with you other person. Delegation of member of management will not cause the member of the manager to cease the member of the manager as a case of limited liability company. 605047002 selection in terms of the manager and the manager managed limited liability company. In a manager management limited liability company, the following rules apply. 1. The manager may choose at any time to consistent with the members or members holding the more than 50% of the current percentage of or interest of the profits of limited liability company owned of its by its all its owners. A person not needed to be a member of the not needed to be a member to be a manager. A person chooses the manager constitutes a member until a successor is chosen, unless the manager at earlier time resigns, is removed, or dies, or in the case of the manager that is not an individual terminates. A manager may be removed at any time without notice, causing the consent of the members holding more than 50% of the current percentage of other interests of the profits limited liability company owned by its own all of its members. Dissociation of a member who is a member removes the person as a manager. If the person who is both manager and member ceases the management, the cessation does not by itself dissociate the person as a member. The person ceasing to be the manager does not discharge the debt, obligation, or other liability of limited liability company or members which incurred with them while a manager. 6050473 Voting rights of members and manager. If a member manages a limited liability company, the following rules apply. A. Each member that has the right to vote in respect of the management and the conduct of the company's activities and affairs. Each member to vote in proportion to the member that the current percentage of other interests of the profit limited liability company owned by all members. C. Except for the otherwise provided in this chapter, affirmative vote of the consent of the majority increase the members and required to do undertaking within or outside the ordinary course of the company activities affairs, including transactions 605-1001, 605-1072. The operating arrangement articles organization may be amended within the affirmative voting or consent of all members. In the manager management limited liability company, the following rules apply. 2. Each manager has equal rights to the management of the conduct of the company activities, but except as expressly provided in the chapter relating to the activities and affairs of the company shall be decided by the manager. If there are more than one manager, the affirmative vote and consent of the majority of the managers. If the action is taken without the meeting by the manager's unanimous consent in a record. See, each member's vote with the proportion that to the members of the current percentage of other interests of the profits limited liability companies own all members. Except otherwise provided in this chapter, affirmative vote consents of the majority interest of the members is required to undertake the act outside the ordinary cause of the company activities affairs, including the transactions 605-1001, 605-1072. The operating agreement articles organization may be amended with the affirmative vote of the consent of all members. 3. If a member is transferred of all portion of the member's transferable interest limited liability to the person who is not admitted as the person in transferring the member is associated in accordance with 605-0602. 5b. The transferring member continues to be entitled to the vote and actual to reserve to the members. The vote of the transferring members being proportionate to the current percentage of the other interest of the profits of the limited liability company owned, and all members that the transfer number would be added to if transfer occurred. And alright, an action requiring the vote disinterested managers, even the disinterested managers constitute less than the quorum. However, the transaction cannot be authorized, approved, or ratified under the subsection solely with the single manager. And two, and the manager and if in a managed limited liability company, a manager limited liability company in which the manager had failed their the contract acted on the subparagraph of the material the facts of the transaction, the member of the manager interest of the transaction disclosed knowingly, the members knowing the material, the facts of the transaction, managers and transactions, and disclosed knowing to the members who voted on upon such transaction. The transaction was authorized, approved, and ratified by the major and the interest of the members, even the disinterest members constitute the less of the quorum. However, the transaction cannot be authorized, approved, or ratified upon under the subsection solely a single member. If neither of the conditions provided in the paragraph 8 has been satisfied, the person depending and the asserting the validity transaction described in subsection 3 of the burden of the providing of the fairness of providing challenging for the validity in the transaction. The presence of voting casting the member in interest of the transaction does not affect the validity of the action taken under paragraph 4a, and the transaction otherwise authorized, improved, ratified, and is provided in subsection 4. But the presence of the vote of the manager member may be counted in the purpose of determining whether the transaction is approved under the subsection of this chapter. In addition, with other grounds, challenge the party challenging the validity transaction is not precluded, asserting providing the particular member of the manager was not disinterested in the grounds financial and other interest purposes of the vote constitute or approve the transaction. 60504-093 limited liability managers and members. Managers and manager managed limited liability company member of the management managed limited liability company is not personally liable for monetary damages. The limited liability company is member of any other person's statement of the vote, decision, failure to act regarding the management and policy decisions of the manager managed limited liability company member of the member managed limited liability company unless A. The manager breached or failed to perform the duties of the manager managed limited liability company, the member or managed limited liability company. The member's breach of the failure to perform the duties constitutes any of the following: A. Violation of criminal law unless the manager of the member has reasonable cause to believe his or her the conduct that was lawful and had no reasonable cause to believe that such conduct was unlawful to run judgment or other final injunction against the manager and the member in the criminal proceeding. The violation of criminal law stops the manager and member from the contesting the facts such as breaching a failure to perform constitute the violation of criminal law, but does not stop the manager in establishing that he or she had reasonable cause to believe that his or her or the conduct was lawful and had not reasonable cause to believe that the conduct was unlawful. The transaction in which the manager made delivered an improper personal benefits directly and indirectly. 3. A distribution violation of statute 6050406 in proceeding with the right of limited liability company to procure in its favor the right of the member the conscious disregard of the best interests in limited liability company with willful misconduct. In the proceeding of the right of someone other than the limited liability company or a member of the recklessness of an action or omission committed with the bad faith, malicious purpose, and manner exhibiting wanton without willful disregard of human rights and safety property is used in section of the term recklessness, meaning acting or failing to act in continuous regard of the risk known as the risk obviously should have been known to the manager and the manager and its limited liability company or to the member of the managed limited liability company is known to the manager. So obviously it should be known to be great as to make it high probable that the harm would follow such an action to failure to act. 3. A manager or manager managed limited company, a company member of the limited liability company deemed to have derived improper personal benefit from any transaction has improved manner and provided 605-04092. Or for it is fair limited liability company is defined in 605-04921C. Circumstances set forth in subsection 3 are not excessive, does not preclude existence existence of other circumstances under the manager managed limited liability company, the member of the managed member managed a limited liability company will deem to have to be derived in proper benefit. 6050410. Records to be kept, right of the member manager and persons associated with the information. Limited liability companies shall be kept in principal office and other locations of the following record. The current list of the full names and the last own business residence, mailing address, each of the members, the manager. A copy of the then effective operating arrangement and made in the record of the amendments, therefore, to if it made record. A copy of the articles of organization, articles of marriage, articles of interest of the exchange, articles of conversion, articles of domestication, and other documentation amendments, therefore continue earning limited liability company which were filed with the department together with executed copies of any powers of the attorney pursuant to the articles of organization such as the documents executed the copies of limited liability company to the federal, state, and local income tax returns of the reports in any of the 3 most recent years, the copies of financial statement limited liability company if in more than 3 most recent years, unless contained with the operational agreement made in the record of the recording statement of the amount of the cash deduction statement of the agreed value of the property, the benefits contributed and agreed to the contributed to each of the member at the time of the occurrence of the events. Additional contributions agreed to be made with each member member manager of limited liability company. The following rules apply. Unreasonable notice that member of the inspection copied during the business hours at the reasonable location specified in the company. 1. The records described in subsection 1 and each of the other record maintained in the company recording the company activities, affairs, financial conditions, other circumstances to extent the information of the material of the member of the rights and duties of the operating arrangement of the chapter. B. The company shall furnish to each member the 1. Without demanding any of the information concerning the company activities, affairs, financial condition, other circumstances of the company knows the material of the proper exercise of the members' rights and duties to operating the arrangement of the agreement of the chapter, except to the extent of the company can establish the reasonable belief the member of the already known information. And 2. The on-demand information concerning the company activities, affairs, financial condition, and circumstances, except to the extent to the demand of information demanding and unreasonable, otherwise improper under the circumstances. Within 10 days after receiving the demand of the pursuant to subparagraph B2, the company shall provide the member who had demanded the record for information. The company shall be provided with the response to demand and where the company will provide the information for the demand. Of this information the company is not providing, and the reason for the company will not provide information. The duty of the furnish the information subsection applies to each of the member, and the extent of the member knows the information described in subsection. If the manager limited the liability company following the rules apply with the information rights of the state subsection 2, the duties in paragraph 2D and the managers, not the members. During the regular business hours, a reasonable location specified by the company and a member may inspect and copy the records described in subsection 1 and the full information regarding the activities, affairs, and financial conditions, circumstances of the company are reasonable if A. the member seeks the information purposes responsibly related to members' interests, and as a member, the member demands a record received the company describing the responsibility, particularly information sought and purpose of the seeking information, if in the injury information is directly connected to the member's person. Within 10 days of the receiving the demand of the pursuant subparagraph 2B2, the company is still in the record information. Members who demand information of the company will provide the response demand on whether the company will provide information of the company. Releasing the declining into the company declines to provide a demand information. The chapter operating the agreement provides the member to give a withhold consent to the matter. Therefore, the consent will be given to withheld. The company without demand will provide the member with the information known to the company, the material, and the member's decision. Subject to subsection 10 days demand the record received the limited liability company. A person associated with the member may not have an access to information with the person who's entitled to while a member. The information pertains to the period of the period with the member. The person seeks the information in good faith. The person satisfies the requirements imposed on the member of the paragraph. 3. The limited liability company shall respond to the demand in pursuant to subsection 4 as in the manner provided in paragraph 3C. A limited liability company may charge the person who makes the demand under this section reasonable cost of the copying, cost limited to the copy, labor, and materials. A member of the person associated with the member may exercise the rights under this section. Agent includes the individual legal disability and is dissolved in the existence terminated through the legal representative. Restrictions condition imposed by the operating arrangement of the under section 10 applies to the agent legal responsibility and the member of the person associated with the member. 8. Subject of subsection. The right of subsection does not extend to the person transferee. If a member dies, 605.05.04 applies. In addition, with restriction conditions stated by the operation arrangement, limited liability as a matter within the ordinary course of the activities of affairs, and is not may impose reasonable restriction conditions on access to use information furnished of this under this section, including the designation of information confidential, imposing non-disclosure, safeguarding obligation, receipts, dispute, and other concerning a reasonable restriction under this subsection. The company has the burden, provided the responsibleness. The subsection does not apply to request a member for the records described in subsection 1. Alright, I'm going to stop at 605.051 because we're about halfway through this now. 605.0411 court order inspection. Limited liability company does not allow a member of the manager or another person to comply with 605.0410.2A and 3A and 3B and 4. As applicable to inspect and copy the records required in the subsection. Required in this section to make available inspection of the circuit court in the circuit where a limited liability company principal officer was last located, and should be records department. There is no principal office in the state where the registered offices was and last located. The most similarly ordered inspection and copy of the records demanding a limited liability company expense upon application of the member of the manager and other persons. If the court order inspection copy of the records demanding the should order the limited liability company to pay the costs, including the responsibility, attorney fees, responsible occurred to the member of the manager, other person seeking records through the obtaining the orders enforcing the rights to under the subsection limited liability company provides. Refused inspection is good for the faith of making the company responsible pays for note for doubt about the right of the member of the management, such as other person inspect for the right of the demand. If the court ordered an inspection copy of the records may reasonably restriction using the distribution records of the members, manager, and any other person demanding such records.